Ripple XRP has won another important victory over the SEC. When do you think the final decision of the court will be announced? How many more victories do you need to convince the court? We will answer all these questions in today's video. XRP lawsuit update. Ripple Labs, the defendant in the long-running legal dispute with the Securities and Exchange Commissions, SEC, has secured another victory. Judge Annalisa Torres granted the U.S. Securities and Exchange Commission's attempt to hide the notorious S. According to court documents, the U.S. SEC sought that the Hinman speech documents be sealed because they include non-public conversations by agency officials. The court, however, dismissed the SEC's challenges to Judge Sarah Netburn's conclusions The notorious Hinman speech papers, according to Judge Netburn, did not fall within the deliberative process or attorney-client rights, as the U.S. SEC asserted. Meanwhile, the Commission went on to argue that problematic papers should be sealed since they are irrelevant to the summary judgment motions. According to the judgment, the court disagrees with the U.S. SEC and considers that the Hinman speech memoranda are court records with a high presumption of public access. The contentious papers are related to the execution of the judicial function and may be beneficial in the judicial process in the eyes of the court. Brad Garlinghouse, the defendant in the XRP litigation, remarked on the current victory against the U.S. Securities and Exchange Commission. He said that this is yet another victory for openness. He also said that the uncensored Hinman email and papers will be made public shortly. The court also rejected the Commission's claim that sealing the records is necessary to maintain openness and candor. The continuing Ripple vs. SEC legal battle took another turn when U.S. District Judge Annalisa Torres denied the regulator's attempt to seal Hinman's speech. Related materials Judge Sarah Netburn ordered the regulatory body to turn over the documents to Ripple for the discovery process months ago. On December 22, last year, the SEC filed a move to seal text messages, expert reports, and internal emails related to Hinman's statements, claiming that its purpose outweighed the public's right to see irrelevance material. Meanwhile, Judge Torres said that Hinman's materials may have an impact on the court's decision. The records in dispute comprise comments and correspondence made by William Hinman, former SEC Director of Corporation Finance. In 2018, an ex-official said that Ether was not a security. Furthermore, the documents include preliminary opinions and an examination of XRP. As a result, the records are critical for Ripple's argument since they demonstrate the SEC's early assessment of XRP. The most recent judge decision permitted the Securities and Exchange Commission to redact the personal information of people identified in Hinman's materials. Torres also agreed to some redactions offered by Ripple. Nonetheless, the judge rejected a number of XRP-related redactions. The FedNow Quick Payment Service is set to launch soon, and on May 11, the Metal blockchain team announced that it would be integrated with FedNow. Metal users may now utilize the send-receive feature of FedNow to immediately convert their cash to stablecoin and back. The partnership between FedNow and Metal blockchain exemplifies the growing convergence of blockchain technology and conventional banking. Metallicus has created a cryptocurrency network called Metal Blockchain, which is based on a fork of the original Avalanche source code. It was created so that developers working on decentralized financial DeFi systems would have alternatives that wouldn't break the law. As a sign of its dedication to identity verification and anti-money laundering, AML safeguards Metal's creators have stressed the network's basis of Bank Secrecy Act, ZO, compliance. Developers may create and apply asset transfer rules on Metal blockchain's X-chain subnet. A token may be issued with some limitations, such as being used exclusively by residents of the United States or being unavailable for trade until the next day. Metal was one of the first blockchain networks to be included as a FedNow service provider, and although the precise criteria for integration with FedNow remain unknown, Metal's adherence to regulatory requirements undoubtedly contributed to its participation. The integration between Metal blockchain and FedNow paves the way for the creation of distributed bank chains. This paves the way for the development of a more robust ecosystem for the blockchain, one that provides security and does away with the need for Oracle. By maintaining a connection to FedNow, banks may coordinate payment processing and settlements. In addition, The adoption of a CBDC and the creation of bank-issued stablecoins that can interact within a basket of stablecoin currencies are both made easier thanks to this connection. Some U.S. politicians, including Florida Governor Ron DeSantis and U.S. presidential candidate Robert Kennedy Jr., are worried about the privacy implications of the integration of FedNow and Metal blockchain and see it as a first step toward a blockchain based despite its potential benefits. The Federal Reserve, meanwhile, has disputed that FedNow is affiliated with a CBDC. Metallicus co-founder and CEO Marshall Hayner responded to complaints about CBDCs by saying they will be subjected to the same degree of scrutiny as the conventional banking system. The integration of Metal blockchain with FedNow, he said, would improve the current financial infrastructure and promote safe and efficient payment processing between banks, therefore putting to rest the issues surrounding CBDCs. Finally, the integration of FedNow and Metal blockchain represents a significant step forward in the world of fast payments and decentralized finance. Because of this connection, consumers may easily exchange fiat currency for stablecoins, opening the door to greater financial inclusion and efficiency. Metal blockchain's approach to regulatory compliance and the possibility of distributed bank chains show how conventional banking institutions and blockchain technology are converging, a trend that will shape the future of digital payments. There are reasonable grounds to believe that XRP cannot satisfy every component of the Howey analysis and is therefore not a security for purposes of the federal securities laws, according to the email. The SEC complaint against Ripple is predicated on the idea that XRP and other cryptocurrencies should be categorized as securities because they fit the Howey test criteria. As a result, any acknowledgement by the SEC or its officials that XRP is not a security in its internal records might be fatal to their case. Deaton speculated that the comment was not a direct quotation from a SEC official and that the person may be referring to someone else's XRP research. Another pro-crypto lawyer, Bill Morgan, believes the message was most likely delivered by an SEC attorney. Morgan said most likely an SEC attorney given how many were involved and commented on Hyman's speech, expressing his personal opinion. Meanwhile, all of this is still supposition, which many feel will be clarified when the SEC reveals the Hyman docs' emails. Ripple has made multiple announcements in the last week, indicating that the business is committed to extending its platform. Ripple paid $250 million for Swiss custody business Medico. According to the company's CEO, Brad Garlinghouse, the acquisition is part of the company's strategy to focus on growth opportunities outside the United States. The cryptocurrency payment provider announced that its BDC platform is compatible with the XRP ledger and the XRP coin.